High Court confidant Ketanji Brown Jackson guarded her legal vocation Monday as legislators gauged her selection to turn into the principal black lady to join the top U.S. court. "I have been an appointed authority for almost 10 years now, and I assume that liability and my obligation to be autonomous truly," Jackson said in declaration before the Senate Judiciary Committee. "I choose cases from an impartial stance. I assess current realities, and I decipher and apply the law to current realities of the case before me, without dread or favor, predictable with my legal promise," the 51-year-old adjudicator said. Jackson's comments finished off the first of 4 days of hearings in the Senate, following long periods of articulations from the board's 22 individuals. Liberals praised Jackson, the main chosen one of President Joe Biden, for her legal experience, her personality, and the notable idea of her climb toward the Supreme Court. The board's Republicans, while for the most part offering some recognition of Jackson's personality, raised a variety of worries about her past decisions and her legal way of thinking. The hearings come as Jackson faces little opposition from a Senate Democratic gathering that can affirm her without GOP support. Legislators won't address Jackson, who at present sits on the U.S. Court of Appeals for the District of Columbia Circuit, until Tuesday. She is relied upon to handle a torrent of inquiries from Republicans on her legal record and theory. Some GOP legislators have proactively condemned Jackson's positions on issues going from court pressing to the lawbreaker condemning of respondents sentenced for youngster sexual entertainment charges. "This is a pivotal event and you have a lot to be glad for," Senate Judiciary Chairman Dick Durbin, DL, told Jackson in the consultation. Durbin, who started the procedures, likewise prudently pushed back on analysis that Jackson will be a elastic stamp for the Biden organization. "For these future pundits, I have 4 words: look at the record," Durbin said. He additionally refuted Republican allegations that Jackson is delicate on wrongdoing, referring to a portion of those charges as baseless. Republicans, in the meantime, proposed that the support of Jackson's bid by purported dim cash political gatherings undercut her nomination. GOP representatives likewise restored grievances of how Supreme Court Justice Brett Kavanaugh was treated by their Democratic partners during his affirmation hearings after a lady blamed him for physically attacking her when they were secondary school understudies during the 1980s. One of the most immediate lines of assault came from Senator Josh Hawley, RMO, who recommended Jackson had given 2 indulgent lawbreaker sentences in some youngster porn cases she regulated as a locale court judge. Durbin and different Democrats accordingly cited a moderate writer who had referred to Hawley's contention as meritless to the mark of demagoguery. Jackson on Monday evening seemed to tailor her comments toward her moderate doubters, who have long jumped on what they consider to be the High Court extending its power and impact past the limited limits set under the law. "I realize that my job as an adjudicator is a restricted one, that the Constitution engages me just to conclude cases and debates that are appropriately introduced," Jackson said. "Furthermore, I realize that my legal job is additionally compelled via cautious adherence to point of reference." She additionally caused to notice her work as a public protector, a piece of her resume adulated by Democrats who say Jackson's experience will carry genuinely necessary viewpoint to the Supreme Court. Jackson would turn into the principal previous public safeguard to serve on the top U.S. seat. Presently, in planning for these hearings you might have perused a portion of my in excess of 570 composed choices, and you might have likewise seen that my viewpoints will generally be on the long side, she said. "That is on the grounds that I likewise have faith in straightforwardness, that individuals should know unequivocally what I think and the reason for my choice," Jackson proceeded. "And my expert encounters as a whole, including my work as a public protector and as a preliminary appointed authority, have imparted in me the significance of having every disputant realize that the adjudicator for their situation has heard them, whether or not their contentions win in court.